I request everyone to take their seats, please. Good evening. Jai Jagannath to all. Today is our fourth law lecture on topics economic offense and its impact on society at large. Is to be delivered by Honorable Shri Justice Sangam Kumar Sahoo, Judge, High Court of Orissa. Sir, I please welcome you on the stage. Today's evening, there is another topic. It's legal pleadings and precedent in general. It is to be delivered by Honorable Shri Justice Dixit Krishna Shripad, Judge, High Court of Orissa. Sir. Today, this occasion, I also I welcome Honorable Justice Pathak sir and Honorable Justice sir, sorry sir, Sahoo sir, and I request our President sir to please take his seat in the podium. I request our Vice President sir, please come to the stage. I request our office bearer, please to hand over a bouquet of flowers to our honorable judges. Sir, I call upon our President, sir, to start the proceedings. Thank you.
Good evening. My Lord Justice Sangam, my Lord Justice Shripad, my Lord Justice Pathak, my Lord Justice senior advocates, my dear friends, brothers and sisters. Actually, when we took over the judge as office bearers and we thought that there should be it should be year should be back year. There should not be left any scope for the members to relax. I think you people must have been scolding us because almost every week after 4:30 we are returning you, but it is for your food. Because I said that from the first meeting I had said that we will be very serious on academic activities as well as the health activities and secondly sports activities. So that we have been trying to do it. Now we have the honor of getting Honorable Justice Sahoo, who is a doyen of criminal law, as an advocate, as well as a judge, and my Lord Justice Shripad. When we approached Justice Shripad about the Justice Shripad said that what subject you have chosen. So the subject we should take no, I'll speak on this particular issue, this pleading and so we said that yes, that is a very good topic. Let us hear. And Justice Shripad also said that I will not deliver a speech. I will have interactive session. Just now in the green room also, Justice Shripad was saying that there will be interactive session. Actually, now, so far as commercial is concerned, well, because immediate speakers are there, so I will not take your time, not spend much time on it. When the commercial law, I mean the offences, economic offences are there. Only one thing I tell you, whenever economic offences means it's all related to, you can say about the commercial law also. Commercial law and all that. So economic offences has become a menace now in India. Now we have been every day we have been reading newspaper, we have been reading that hundreds of crores have been swindled away by the cyber thieves. And also people, somebody is cheating and all that, some persons are running away from the country by taking huge loan and burdening the country with some thousands of crores. So like the economic offense has become very much important and is a burning topic now. That is the reason why we are grateful to Honorable Justice Sahoo who agreed to speak on this subject. Now, so far as pleading is concerned, I thank my Lord Justice Shripad because pleading actually in our days, when I joined practice 47 years back, Pleading was an important integral to all the petitions, even time petition also. When we were writing time petition, we used to write because there was judgment at that point of time that time petition cannot be granted. So time petition writing saying that because of all the difficulty of the lawyer, lawyer is not able to appear, but that is not ground to grant time. So that the client, the petitioner, or the plaintiff or defendant, he doesn't have any time to engage another lawyer within a short time. That's the reason it seeks some time. That was the writing. Because based on the judgment, time petition also were writing based on the judgment or law laid down by the Honorable Supreme Court. So that was the kind of year. In the Order 7 and Order 8, these are the two. I'm sure that my young friends they must have read this Order 7 or Rule 8, Order 7 or Order 8 of the CPC. Very much important. In criminal law also, drafting is also very important because and in civil, especially in second appeal, when we were drafting second appeals, substantial question of law, of course, that is substantial question of law came subsequently. That is, but substantial question of law, when I used to, our senior, my learned senior, Dr. Bipin Bhairotha, and my earlier senior, Mr. Vibhuti Rath, both of them were brilliant lawyers. So they were saying that ground, first read the law, find out the judgment, then make out a ground, and in the backside of the in office copy, backside of the ground, you just write the citation, so that when matter will be heard, you will or anybody who will argue the matter, it will be easier for him to argue the matter. That is how the importance of pleading is. So that is the reason why my Lord Justice Shripad has chosen this topic, where I am really grateful, and it will be really of great assistance to my friends. Thank you. Now I request Honorable Justice Shripad to. Sorry. May I request my Lord Justice Sangam sir to deliver his speech.
Good evening. My esteemed President, Secretary, and Vice President,
आपके हाइट Sir, since it is a PowerPoint presentation, maybe sir can see from this side. Say,
my esteemed
see that, sir.
brother judges,
Front screen is not like provided yet.
and members of the bar,
That's why people see this count.
this topic was assigned to me. Most of the thing I have mentioned it from the experience on the bench, because I did through it so many bail applications and other applications relating to the economic offences. So the study was at that point of time, and when I went through my own orders judgment, it helped me a lot. And after I made this preparation, I requested the CPC to make it a PowerPoint presentation, because I think that it would be helpful to the young members of the bar. And if you are not having any notebook with you, please don't worry, because this program is being
live stream, and afterwards you can see it also, but listen carefully. So the topic is economic offense and its impact on society at large. In Odia, if we translate it, becomes अर्थनैतिक अपराधर सामाजिक प्रभाव. This begin with a quotation from John Kenneth Galbraith, states that crimes of violence strike at the body. Okay. But economic crimes strike at the soul of the society. Now, what are the economic offenses that we first know? This economic offenses are the crimes committed during course of economic or business activities that cause financial harm and adversely impact the country's economic well-being and financial health. Economic offenses typically involve fraudulent activities such as tax evasion, money laundering, bank fraud, securities scams, corporate fraud, smugglings, and corruption that affect both public and private financial interests. Economic offenses are considered more serious than conventional crimes as it affects the entire economy and pose a serious threat to the financial health of the country while shaking public confidence in the financial system. Economic offenses often involve complex transactions, sophisticated methods, significant amount of public money, making them different from the regular offenses and requiring specialized investigation and prosecution approaches. Economic offenders are having sentiment of probity which increases criminality against society based on psychology orientation. In economic offenses, the victims are usually the state or a section of public, particularly the consuming public. Economic offenses in particular can be committed from anywhere with the misuse of the technology initially invented for overall welfare and benefit of the mankind. The internet has made it very simple and feasible for the economic offenders to go their work without getting physical with their targets. Economic offenses are finding a new modus operandi every day. Qualifications of the offenders, like being in particular profession or occupation, or having specialized skill or professional and technical nature. Economic offenses are calculated to prevent or obstruct the economic development of the country, endanger its economic health, including evasion of taxes, misusing of position by public servants, hoarding, black marketing, adulteration of food and drugs, theft and misappropriation of public property funds, trafficking in license and permits. Offenders of economic offences have a motive of greed, materialistic avarice, or rapaciousness, and operation mode of these offences is fraud, not force, deliberate and willful. Now, what is the difference between the normal crimes and economic crimes? Now, normal crimes, also known as traditional crimes, and economic crimes are distinct categories of criminal activities, though both can have serious consequences. Traditional crimes such as murder, theft involve direct physical harm or property damage and are typically dealt with general criminal law. Whereas economic offences, on the other hand, often involve financial transactions and can have widespread impacts on the economy and public welfare, and often governed by specific legislation. Violent crimes result in direct physical injury and fear, affecting individuals and their immediate surrounding, whereas economic crimes undermine the ethical and moral fabric of the society, eroding trust in financial institutions and justice system. Economic crimes have far-reaching consequences, damaging societal values, and its impact is on the broader population by undermining the economic stability and welfare of the nation. Such offences are driven by greed and planned meticulously for financial benefits. Economic offences having deep-rooted conspiracies and involving huge loss of public funds. Such offences are called white-collar crimes. The economic offences erode investors' confidence, disrupt market stability, deter foreign investment, and ultimately hampers economic growth. Economic offences such as fraud and embezzlement primarily affect the national economy and cause widespread monetary losses to the public. Economic offences include money laundering, fraud, tax evasion, and cheating. The entire community is aggrieved if socio-economic offenders who ruin the economy of the state are not brought to the books. Thus, economic offences are arguably more severe than bodily damages due to their calculated nature and widespread impact. Economic offences are well planned and managed. Illegality is primarily involving deception and betrayal committed generally without coercion against the individuals or the public, exclusively for maximum personal financial gains of the perpetrators, with or without taking undue advantage of any or more of the technical know-how, power, position, responsibility, and system lacuna, being capable of affecting adversely, directly or indirectly, the society as a whole in terms of any or more morals, values, health, and economy, with consequent after effects over any or more of the national growth, security, defense, and development, apart from triggering cross-border issues and or global concern. Economic offences form a separate category of crimes under criminal offences. Socio-economic offences are crimes that have impact on society's economic and financial well-being. Economic offences not only inflict pecuniary losses on individuals, but also damage the national economy and have security implications as well. Now, what are the roots of economic crime and financial fraud? The roots of economic crime and financial fraud generally have several legal elements such as misrepresentation of a material fact, knowledge on the part of the accused that they were misrepresenting the fact. Misrepresentation was made purposefully with the intent of fooling the victim. The victim believed the representation and relied on it. The victim suffered damage as a result of the misrepresentation. Another root cause identified behind the increasing rate of economic offences using internet has been conceptualized is that the invention of the internet was never intended for commercial business but for research purpose only, making all of its protocols open and unsecured, and this is the reason that data, including the confidential ones that are transmitted over internet, are easily intercepted and stored. Now, what is financial fraud? Financial fraud includes mail fraud, bank fraud, tax evasion, bankruptcy fraud, security fraud, racketeering, wire fraud, embezzlement, and counterfeiting. Civil fraud is a private dispute typically between the individuals or organizations where the goal is to recover losses or receive compensation. Criminal fraud, on the other hand, involves violation of law prosecuted by the state and potentially leading to fines, imprisonment, or other criminal penalties. Now, I'm coming to the glaring examples of economic offences. Now, the cheat fund companies, what they have done in our state for last 20 years, that is really shocking. And this cheat fund companies used to defraud the public through various means, often involving deceptive practices and illegal operations. Common schemes include diverting invested funds into loss-making ventures, misappropriating the funds, and failing to return investment after the cheat fund cycle ends. They may also operate unregistered cheat funds, gaining investors' trust through motivational speeches and misleading promises before abruptly shutting down and absconding with the money. Now, misappropriation of funds is diverting to sister concerns. So the cheat fund companies establish sister concerns or related businesses that are not financially viable, and they then allegedly divert investor funds into those loss-making ventures, effectively siphoning off the money. Even without sister concern, companies may simply misappropriate funds for personal use or other unauthorized purposes, leaving investors with nothing when the fund cycle ends. Now, operating without registration, this is unregistered and illegal operations. Cheat funds are required to be registered with the relevant authorities. Unregistered cheat funds operate outside the legal framework and lack transparency, making it easier for them to defraud investors. And deceptive practices are there These companies may use aggressive sales tactics, motivational speeches, and promises of high returns to lure investors, often targeting vulnerable populations. Then sudden shutdown. Unregistered cheat funds may operate for a period, building trust before abruptly closing down and disappearing with investors' money. Then violation of the Cheat Funds Act 1982. It is non-compliance with regulation. Even registered cheat funds can engage in fraudulent activities by violating the regulations set by the Cheat Funds Act 1982. Failure to conduct auctions. The Act mandates regular auctions for cheat funds. Companies may fail to conduct auctions or manipulate the process to favor certain individual, depriving others of their share. Non-payment of dividends. Companies may fail to distribute the dividends to the subscribers as per the terms of the cheat funds, or they may delay or default on payment. And what other deceptive tactics the cheat fund companies adopt? High pressure sales. Agents may use high pressure sales tactics, making it difficult for the investors to fully understand the risk involved. And misleading information. Companies may provide false or misleading information about the fund's performance, safety, and returns. Exploitation of trust. They may exploit existing relationship and trust within communities to gain investment. So in essence, cheat fund scams often involve combination of illegal operation, deceptive practices, and a lack of transparency, leaving investors vulnerable and facing significant financial losses. Now, I'm coming to this. There are several cheat fund companies in our state operating, and one of them is this Orthotattva, which is known as AT Group. And this Orthotattva Group is a financial group in Orissa, and that become embroiled in a major cheat fund scam. So the main accused was a computer science diploma holder from Ganjam district, and he left his sales job at an insurance company to start 9 farms under Orthotattva Group that had interest in cooperative society, housing, infrastructure, insurance, equity management, healthcare, knowledge process, outsourcing, information technology, computer hardware product, including a laptop brand called Systematics, food products, retail and security. So the group promised houses at cheap rates in Bhubaneswar, Baleshwar, Barampur, starting a cooperative bank. The group registered under the Companies Act and Multi-Share Cooperative Societies Act, collected money from small investors in Orissa with a promise of high returns ranging from 15 to 20%. Less than a fortnight after this gentleman started his company, the state cooperative department named him as the best young cooperative person. By 2012, a year after he started Orthotattva, he rode cars, traveled abroad, hosted parties in Mumbai, invested in real estate in Kolkata, funded TV serials, Odia films. Some of the earliest investors, they got their money back, but soon the payments dried up. In February 2015, some of the investors filed FIR against the main accused at Baleswar police station. And by then, he has reportedly collected 500 crores from the public. He was arrested and taken into judicial custody. The Supreme Court estimated the cheat fund scam in Orissa to be worth of 4,600 crores, almost 2 times of Sardha scam in Bengal. But officials take it over rupees 20,000 crores. The group collected money from the investors with promise of high returns, but ultimately failed to deliver, leading to widespread financial losses for many. This scam involved fraudulent activities, including money laundering, and resulted significant legal action and asset confiscation. The Orthodox group was involved in a large-scale cheat fund scam in Odisha. The cheat funds are informal saving schemes where investors pool money and expect high returns, but the Orthodox group allegedly used deceptive practices to defraud investors. One commission was set up by the government, Hon'ble Justice M.M. Das, Commission of Inquiry. He was probing the cheat fund scam and he recommended compensation for 4,97,844 small investors, while naming more than 450 companies for cheating the investor in its internal report to the state government. Friends, you know that our affidavits were invited and they were supposed to file the documents of their investment in the cheat fund, and that was scrutinized, and it was found that in Orissa 450 companies, cheat fund companies, were operating. And the previous government refunded 119 crores to 2,79,109 small depositors within a span of 10 years, that is from 2014 to 2024. And the new government has refunded rupees 47.07 crores to 1,26,137 small depositors who were duped by cheat fund companies within a year. Now, the another scam is a Ulipuri mining scheme, and this mine is located in Juda mining circle in Keonjhar district of our state, where large-scale irregularities were detected by State Mines Department. Justice M.B. Shah Commission, which probed a number of mining scam cases, had turned this particular case as one of the biggest illegal mining ever, even as it recommended a CBI probe into the matter. The Sahoo Commission, while recommending a probe by a central agency in this case, had desired that all the cases should be handed over to the CBI, where the FIRs were registered by police, vigilance, mines, revenue, forest, and other departments from 2008 to 2011. The Enforcement Directorate registered a money laundering case in the 2,000 crores Ulipuri mining scam in Orissa. How these cheat fund scam cases were investigated by CBI? Some writ petitions were filed seeking transfer of investigation from state agency to the Central Bureau Investigation in cheat fund scam cases of state of West Bengal and state of Orissa. And the decision is the leading decision, Subrot Chatoras versus Union of India and others, 2014-58 UCR, Supreme Court 905. and I'm just quoting the Honorable Supreme Court why and how it transferred the investigation to the Central Bureau of Investigation. It is quoted like this. More importantly, the question is whether this scam was confined only to those who actively managed and participated in the affairs of the companies, or the same flourished on account of support and patronage of others, is an issue that has bothered us all through the hearing of the case. All that we need to point out is that investigation into this scam is not confined to those directly involved in the affairs of the companies, but may extend to several others who need to be questioned about their role in the sequence and unfolding of events that has caused ripples on several frauds. Suffice it to say that the scam of this magnitude is going on for years, unnoticed and unchecked, is suggestive of a deep-rooted apathy, if not criminal neglect, on the part of the regulators, who ought to do everything necessary to prevent such fraud and public loot. Depending upon whether the investigation reveals any criminal conspiracy among those promoting companies that flourished at the cost of common man, and those were supposed to prevent such fraud, calls for a comprehensive investigation, not only to bring those who are responsible to book, but also to prevent the recurrence of such scams in future. An affidavit has been filed by the state of Orissa pursuant to the state direction, in which affairs where the state investigating agencies examining the larger conspiracy angle have been identified. Larger conspiracy angle is, according to the affidavit, being examined in 3 cases. The factual narratives given in the foregoing paragraphs clearly establish the following. The financial scam, nicknamed cheat fund scam, that has hit the states of West Bengal, Tripura, Assam and Orissa, involves collection of nearly 10,000 crores from general public, especially the weaker section of the society, which have fallen prey to the temptation of handsome returns on such deposits extended by the companies involved in this scam. That investigation so far conducted revealed involvement of several political and other influential personalities wielding considerable clout and influence. The question is whether the above feature call for transfer of the ongoing investigation from the state police to the CBI. Our answer is in affirmative. Investigation by state police in a scam that involves thousands of crores collected from public allegedly because of patronage of people occupying high position in the system will hardly carry conviction, especially when even the regulators who are expected to prevent or check such a scam appear to have drawn blind eye to what was going on. The state police agency has done well in making seizures, in registering cases, in completing investigation in most of the cases, and filing charge sheet and bringing those who are responsible to book. The question, however, is not whether the state police has faulted. The question is whether what is done by the state police is sufficient to inspire the confidence of those who are aggrieved. While we do not consider it necessary to go into the question whether the state police have done all that it ought to have done, we need to point out that money trail has not yet been traced. The collections made from the public far exceed the visible investment that the investigating agency have till now identified. So also the larger conspiracy angle in the state of Assam, Orissa and West Bengal, although under investigation, has not made much headway, partly because of interstate ramification, which the investigating agency need to examine but are handicapped in examining. In these circumstances, that is the observation of the Honorable Supreme Court, we are inclined to allow all these petitions and direct transfer of the following cases registered in different police stations in the state of West Bengal and Orissa from State Police Agency to the Central Bureau of Investigation. And in state of Orissa, all the cases registered against 44 companies mentioned in our order dated so and so were transferred. The CBI is also permitted to conduct further investigation into all such cases in which charge sheet have already been filed. So now I'm coming to the case which I did after this judgment was pronounced, and this matter was argued before me by a counsel who is now the Learned Advocate General of the state from the side of the petitioner, and from the side of CBI, who is now a judge of this court. So the petitioner in that case was the sitting MLA of Banki Assembly constituency in the Orissa Legislative Assembly. He approached the Orissa High Court in an application under section 438 CRPC apprehending arrest in connection with a cheat fund case. As I found that the charges in the case was very serious and relates to commission of economic offences, and the accused persons in the case took advantage of the depositors' quest to make quick and easy money and ultimately deprived them of their hard-earned money. I went through the investigation report of the main accused. His name is Kumar, the forensic voice examination report, the transcription of CD, the statement of the Cooperative Society Registering Authority, as well as seizure of 153 sheets of documents of Orthotattva from the bedroom of the official quarters of the petitioner at Bhubaneswar, and held that it prima facie establishes the link of the petitioner in the crime, and accordingly I rejected the application. The next case is Preeti Bhatia versus Republic of India, which also I did and delivered the order. The informant in those cases alleged that they, along with other depositors, paid huge amounts to Orthotattva group of companies for getting higher returns in terms of interest and incentives under various schemes quoted by the 80 group of companies, and the cheap plots under various projects undertaken by the 80 group of companies, represented by its Chief Managing Director Pradeep Kumar Sethi. The company neither returned the amount due to depositors' investors as agreed upon, nor constructed the flats as per the agreement, and also did not sell the alleged land to the investors, public depositors. When the investors and depositors asked to refund the money paid to the company, accused Pradeep Sethi and other directors of the company closed down the branch offices at various places of Orissa, as well as the head office of the 80 group of companies located at Hon'ble Nagar, Bhubaneswar, and vanished overnight after duping thousands of gullible investors to hundreds of crores of rupees. Investigation further revealed that accused Pradeep Sethi and others, in furtherance of the criminal conspiracy hatched among them, formed a number of companies within a very short period in quick succession and registered the companies with the Register of Companies Qatar and also the Register of Companies Mumbai. And one of such 11 companies was Prism Heights Films and Entertainment Private Limited. As per the Memorandum of Association and Article of Association, the main objective of that particular company was to carry on the business of production, marketing and distribution of feature films, telefilms, documentary films, advertisement films, television shows, TV serials, drama, theatrical, arranging cultural shows and other entertainment programs and software related thereto in India and abroad. The investigation further revealed, as per charge sheet, that the petitioner Preeti Bhatia was one of the directors of that Prism Heights company, and as a director, she was actively involved in the affairs of AT Group and used to visit the head office of AT Group, frequently attending the meeting. And investigation revealed that 1 crore 17 lakhs 83,000 illegally diverted to the personal account of this petitioner from the AT Group of companies without any justification, which indicated that in criminal conspiracy with the main accused, the part the said amount illegally collected. So accordingly, he misappropriated the same, and I rejected the application. The third one is a member of parliament. He was from the 16th Lok Sabha in 2014 from Moyurbanj constituency in Orissa, and I did this matter. He, along with the accused persons, floated number of companies like Navadiganta Capital Services, Navadigant Properties, etc., etc., and they registered with the Register of Companies in 2011, and the petitioner and 5 other directors, what they have done, that they were the key persons in the management and collected huge deposits from the public, alluring of higher returns through the companies, and the evidence further revealed that they were carrying forward the day-to-day business of the companies and cheated the depositors, and deposited amount have been misappropriated by them. And investigation further revealed that the accused persons have maintained different accounts in different banks, and the certificates were issued to the investors under the signatures of the petitioner and others, and it revealed that that the guidelines of the Reserve Bank of India were not complied with by the company while issuing debentures to the public at large, and the list was furnished before me, and I found that the prima facie case was made out against that petitioner and 2 accused persons who have entered into the criminal conspiracy, collected money from public with dishonest and fraudulent intention, alluring of higher returns by violating the norms of the RBI and Companies Act, and they cheated the public to the tune of 8 crore 39 lakh 1,508. So that is how the bail application was rejected. Now I'm coming to another decision which in that economic offense, Deepak Gupta, it is relates to that Puliboli, and he was the director of the Sneha Purush Marketing Private Limited and power of attorney holder of PK Mahanti Mines, and he, along with another Harisharan Gupta, they were the lease holders, and they indulged in illegal theft of iron ore of the suppressed quantity which have been clandestinely sold by entering into criminal conspiracy with the noted mining, forest and revenue officials without the payment of royalty. Dishonestly and fraudulently sold the illegally extracted iron ore at a very low price to his own group of companies. This Deepak Gupta and the companies indulge in illegal mining much beyond the permissions given by the mining officials. And can you imagine what is the loss? According to the charge sheet, the loss was 1,520 crores, and accordingly, the charge sheet was submitted, and investigation revealed that this Deepak Gupta, he entered into criminal conspiracy with public servants of mining department, forest department, revenue department, and in pursuance of such conspiracy, they dishonestly and fraudulently indulged in illegal mining from the reserve forest area and government land much beyond the mining lease and of Sri D.K. Mahanti, and that is how the bail application was rejected. And the last decision I am placing before the August audience is Srikant Mohta. He is a man from West Bengal and a very eminent producer, film producer. He relates to Rose Valley Group of companies. That Rose Valley Group of companies collected huge amount of money from public, enticing them with false promise of paying higher rates of interest, and the Rose Valley was having no authorization from the Reserve Bank of India or SEBI to carry out these activities. Rose Valley, in furtherance of the criminal conspiracy by establishing branches of the companies in different parts of the India, collected money from the public through multi-level agent network system. They cheated the investors and the depositors by way of camouflage schemes and false assurance about legal sanctity and false promise of higher rates of interest. They cheated the depositors and the agents by making false assurance that the accused companies were legally empowered to collect money from the public. They were running Ponzi schemes and circulating the money collected from depositors, which was not disclosed to the depositors and agents. And they made false propaganda that Rose Valley was having big business empire and diversified business, and they did not return money of lakh of depositor and committed criminal breach of trust. And the collection of Rose Valley money, it goes to more than 1,471 crores. So this lucrative offer of the Rose Valley and myriads of huge outturn on investment as projected successfully during telecast of Bengali feature films produced by the petitioner's companies, the Srikant Mohta's company in satellite channel Ruposi Bangla, mesmerized the gullible investors for collecting pearl of higher interest. The investors drowned themselves in the sea of treachery. Before they could wake up from the deep slumber, they had already been trapped and squeezed and were left out with tears in their eyes, which never dried up. The incomprehensible pain and suffering of those hundreds and thousands of investors are apparent, and I heard that nobody knew that when and how they will get back their money. So business tycoons played the game with people's money very cunningly, with active support of some high-level politicians, police officials, and film personalities. It was bed of roses for them, but bed of thorns for the investors. And this Srikant Mohta was the chief promoter and main director of SBFEPL, and he got close link with accused Gautam Kundu, and it was Traced House, and he was a top producer of Bengali film industries, known for production of quality films and wielding considerable clout and influence on the television audience. And Gautam Kundu wanted the Bengali films to be produced by the petitioner to be telecast in the channels of BBCL for capturing more and more audience, and the petitioner entered into the business alliance with accused Gautam Kundu, which was in the nature of criminal conspiracy to divert the ill-gotten money of Rose Valley in the guise of commercialization. So, secret meetings were held between them. Accused Gautam Kundu disclosed before the petitioner of his actual cheat fund business and requested him to promote his media business by supplying good films produced by SVFPL, which would be utilized for branding and promotion of cheat fund business. The petitioner knew all these facts regarding the illegal cheat fund activities of Rose Valley, that it had been banned by SEBI in the year 2002. Still then, he entered into agreement and other business alliance with accused Gautam Kundu for films assignment relating to the sole and executive satellite television broadcasting rights in respect of 70 films through channel Rupsi Bangla, a channel of BBCL, for consideration amount of rupees 25 crores. So the petitioner intended to receive the ill-gotten money in the garb of genuine business deal agreement with accused Gautam Kundu and conspired to cheat the general public, since the amount received by him on the guise of business transaction was the public money. In Rupsi Bangla, the advertisement of Rose Valley was shown on a regular basis, and in that process, SVFPL helped the BBCL to enhance its revenue generation and also its prestige. Now, I have quoted some of the judicial observation with regard to the economic offences. The citations I have given, one is State of Gujarat versus Mohanlal Jitamalji Porwal, that is 87 to SCC 364, YS Jaganmohan Reddy versus CBI 2013-7 SCC 439, Ashwini Kumar Patra versus Republic of India 2021-84 Orissa criminal reports. But the lordships have stated that economic offences are always considered as grave offences, and it involves deep-rooted conspiracy and huge loss of public fund. Such offences are committed with cool calculation and deliberate design, solely with an eye on personal profit, regardless of consequence to the community. It brings about total imbalance in the economy of the country, which has the effect of making the life of people economically weaker and miserable. Such offences are treated worse than murders. In such type of offence, while granting bail, the court has to keep in mind, inter alia, the larger interest of public and state, the nature and seriousness of the economic offence and its impact on the society are always important consideration in such case, and those aspects must squarely be dealt with by the court while passing an order on the bail application. So, the judicial observation with regard to the economic offences I have just jotted down. Economic offences having deep-rooted conspiracies and involving huge loss of public funds. Those offences are affecting the economy of the country as a whole, and thereby posing serious threat to the financial health of the country. These offences need to be viewed seriously and considered as grave offences. The economic offence is committed with well-planned, full calculation and deliberate design with an eye of personal profit, regardless of consequence to the society at large. The entire community is aggrieved if the economic offenders who ruin the economy of the state are not brought to book. The economic offences in this era are actually public wrongs or crimes committed against society. The gravity and magnitude attached to these offences are concentrated at public at large. The economic offences stand on a graver footing. These crimes are professionally committed by white-collared people. These offences inflict severe injuries on both health and well discrimination. In economic offense, the viewpoint is to be taken differently with different approach in case of bail. Such offences need to be dealt with heavy hand, and releasing such accused on bail will affect the community at large and also jeopardize the economy of the country. The economic offences have deep-rooted conspiracies. These offences involve use loss of public fund. These offences need to be taken seriously, considered as grave offences. They affect the economy of the country as a whole, posing serious threat to the financial health of the country. The public finger of accusation with regard to the economic offences is the seriousness of the charge. The economic offences result in loss to the state exchequer. Unfortunately, in the last few years, the country has seen an alarming rise in white-collar crimes. The crime has affected the fiber of the country's economic structure. The economic offences are nothing but private gain at the cost of public and lead to economic disaster. Such serious offences are a threat to safety and security of money of the customers lying in the bank. If such offences are viewed lightly, then the confidence of the public will be shaken. The economic offenders who continue to reap the benefit of the crime committed by them do not deserve any indulgence. Any sympathy to these offenders would not only be entirely misplaced, but also against the larger interest of the society. Such offences are preceded by cool, calculated, deliberate design with an eye on personal gains. These offences bring imbalance in the economy of the country, which has the effect of making the life of majority of people, particularly those belong to the economically weaker sections of the society, miserable. The ever-growing materialistic outlook in the economic offences set the unscrupulous elements on a prowl to maximize material gains by unlawful means. The economic offences involve the kind of activities showing a great deal of deliberation, preparation, and operation which can be done only by an intelligent person. The whole exercise in these offences is actuated by a mentality to get richer overnight at the instance of general public or investors. This offense committed with a mentality of class of people who have capacity and temerity to lead a lavish life and create assets are the miseries of general public, making them invest their hard-earned money with them. Criticism from quarters with view white-collar crimes with a permissible eye, unmindful of the damage done to the national economy and national interest is required, not to be given any emphasis. Economic offense constitute a class apart and need to be visited with a different approach. Parts of the courts for anticipatory well under section 438 CRPC, which is now 482 BNSS, being an extraordinary remit, has to be exercised sparingly, more so in cases of economic offences. Economic offences stand as a different class as they affect the economic fiber of the society. Now, a latest decision of the Honorable Supreme Court I am placing before the August audience, that is 2025 SCC Online, SC 929. Party name is Dinesh Sharma versus Emic Cables and Communication Limited, where the Lordship, while dealing with the issue of economic offences, has observed the consequence of the act complained of upon the financial or economic system will weigh in the balance. Thus, it can be concluded that the economic offences by their very nature stand on a different footing than other offences of wider ramification. They constitute a class apart. Economic offences affect the economy of the country as a whole and pose a serious threat to the financial health of the country. If such offences are viewed lightly, then the confidence and trust of the public will be shaken. Now I am coming to the conclusion that socio-economic offences pose a major threat to the Indian economy and society, undermining public trust in the financial system, attracting foreign investment, using government resources, and slowing economic growth. The government and law enforcement should take effective efforts to confront these crimes and ensure a safe and stable economic environment for all. Socio-economic crimes not only affect persons and business, but they also have far-reaching economic implications. As a result, it is critical to have strong legal structure capable of properly dealing with those offences. The socio-economic crimes, current rules and regulation must be strictly enforced. To prevent and uncover these crimes, the government and the law enforcement agency must collaborate closely with financial institutions, regulatory bodies, and other stakeholders to identify and investigate the offences. A coordinated and proactive approach is required, which includes the use of technology, data analysis, and other modern techniques. Furthermore, there is need for increased public understanding of the economic and social consequence of the socio-economic offense, which can be accomplished through education awareness program that enlighten people about the dangers of financial crime and how to protect themselves. I thank the Latin President and other office bearers giving me a chance to tell something about this topic, and I hope that this topic, this discussion will be helpful, particularly to the young generation. Friends, I would say that a lot of pain has been taken by while preparing the same. I am handing over the same to the Secretary of the Bar Association with the pen drive. Apart from that, it is being live sent and also. Thank you very much. Namaste.
Thank you, sir. It was very enlightening and enriching. Sir, with the august presence of our Honorable Chief Justice, sir, is here, we are really encouraged. Thank you, sir, for being here. We are also encouraged with the presence of Honorable Justice S.S. Mishra, sir, Honorable Justice B. Singh, sir, and also Honorable Justice S.K. sir. So now I call our Justice Dixit sir to deliver his address.
My beloved Chief Justice and the brother judges, office bearers of the association, ladies and gentlemen. Whenever I am asked to give a lecture, I am a bit hesitant. I confess. Perhaps you might have heard of Dale Carnegie, the great author of How to Win Friends and Influence People. He was asked, which is your next book? And he said, very curious title, How to Distance Friends and Antagonize People. And the questioner asked him, how you are going to accomplish that? He said, in the evening of a busy day, by giving a long lecture, you can achieve that. With this prefix, I start this topic I'm not very sure that you will be impressed by that because you have heard a very wonderful speech of my brother judge, Mr. Sahoo, like a Nile river flowing slowly without any galata. He completed his speech. My topic is the one which is of daily involvement, pleadings and precedents. There are at least half a dozen best books on pleadings. One is by P.C. Mogha, Pleadings. Is one of the best books. In at least two of the Supreme Court judgments, Mogha is praised by the apex. Archbold's Pleadings. It's an English law of pleading. Very, very concise. Then A.B. Majumdar, he hails from our Honorable Chief Justice's place, who is an acclaimed author of law of notices. Yes. I thought that you were seeking Passover. Pleadings, Mogha says, determine the battle lines. Any criminal case, civil case, revenue case, rent case, service case, labor case, land case, tenancy case, whichever case you take, ordinarily there are two sides. One asserts, the other disputes. If you see Section 5 of the Evidence Act 1872, it says evidence can be led to prove facts in issue and facts relevant to the facts in issue and nothing else. So, facts in issue. Then evidentiary aspect of facts in issue. You have seen in CPC, the appendix gives the model pleadings. You should plead only the facts. One exception is little evidentiary pleading you have to take up in rich jurisdiction because evidence is not recorded that way. But ordinarily, in all proceedings, be it civil or criminal, in civil it begins with plaint, in criminal it begins with complaint or FIR, as the case. The first rule which Archbold suggested to prepare for the pleadings is to know the substantive law, the procedural law, the adjective law. If you have to plead, what is that you are going to plead? You are pleading the title facts with Sangam in jurisprudence, 12th edition, Fitzgerald's edition, gives what is meant by title facts. Title facts means which will give rise to rights and obligations of the parties, immunities and capacities of the parties. Unless you know this substantive law, you will not be in a position to plead at all. One case I report, perhaps 1881 or 82, I do not remember the exact year. Its name you can check from Google. Name of the case is Great Northern Railway versus Walker. Walker was born with a deformity at birth. He had sued the railway company, saying that because of the railway accident, I contracted deformities. I am born with deformities. The company did not take the required amount of care and caution when my mother was traveling, and therefore the company should be made to pay the compensation damages. Then the pleadings were drafted in such a way that he was a person, legal person, capable of rights and duties, and therefore he is entitled to damages for the wrong which he suffered at the hands immediately of the railway company. The defense side filed their objections. The first objection is the mother did not buy a ticket for the child in the womb. Therefore, there was no privity of contract. The second objection is mother never told that she was an expectant mother. And third one was the person on behalf of the railways who had issued the ticket, sold the ticket, had no idea, only by seeing her tummy, that she is a pregnant woman. He thought that she was a woman heavily built. Then the last is very important. The plaintiff was not a legal person as on the day they suffered these injuries. Because the medical report stated he had suffered these deformities by virtue of the accident only, but before he came out and saw the light of the day. See the way the pleadings are drafted. How many aspects? One is whether he is a person or not. An unborn person is not a person. A dead person is also a not person. Is it? In Hindu law, of course, in unborn for an unborn person, limited rights, contingent rights are recognized, like partition, etc. But unborn person, ordinarily, in all civilized jurisdictions, is not a person. So unless you have the idea of person, legal personality or capacity, you will not be in a position to take up a particular contention. Number two, she did not buy a ticket at all. Then comes the privity of contract, which is a matter governed by the law of contract, substantive law of contract. The second. Third one is the duty of care. It takes you to the law of tort. Unless you know the law of tort, you will not be in a position to take up that contention, nor will you be able to meet the contention taken. In a very important case, Dred Scott, very important case of America, brothers will be knowing, which was fought in American Supreme Court in 1857, when our war, Sipahi war, the first struggle for freedom was taking place in India. The contention was, Dred Scott was a Negro. He escaped from the clutches of his master, went to one of the states in America, I don't remember that name of that state, where the slavery was abolished. The question arose whether Dred Scott is a person or property who can be owned. A person cannot be owned by another person, whereas property can be owned. See the intricacy. And the American Supreme Court ruled, all of you know, based upon the ideas, ideologies, philosophies of those days. Therefore, I cannot dwell upon that. I am just highlighting the importance of substantive law in preparing your pleadings. First question will be, how are you going to ascertain the law? What is law? What is fact? What is mixed question of law and fact. Therefore, you have to go to the sources of law themselves. This is what Julius Stone, a great scholar, wrote like this. He says, and of course you have seen in someone's jurisprudence also, there are at least 4 sources of law, traditional sources of law. Legislation, custom. Legislation is made by traditional legislative bodies like parliament, state legislatures, like that. Then custom is law made by society. Legislation arises from the state. Custom arises from the society. Then contract is also a law as between the parties because it regulates your rights and liabilities. The 4th one is precedent. You have seen Article 141, our Article 250, 226, 227, 228. The Supreme Court, law declared by Supreme Court shall be binding upon everyone. So precedent becomes law. So you should know not only just legislation, you have to know if there is a custom, you have to plead the custom, essentials of the custom. And if there is a contract, you have to plead the contract, the essentials of contract, why it is enforceable, why possible defense is not available to the other side. Then the last one is the opinio juris, a very feeble source of law. But in international law, opinio juris has a great term. Of course, this is what judges taught in international law, by open game, by his international law, he says that. So, the law and the facts, first you should have complete, clear idea. Someone discusses law and the fact in a separate chapter. He says all questions which arise before the courts of law are of 4 types. One, questions of law. The second one, question of fact. The third one, question of opinion. The 4th one is question of discretion. Question of law, someone roughly says, to a great extent, Apex Court also has agreed in 2 decisions, that any question which ordinarily needs to be answered by turning the pages of the statute book is a question of law. Whether this particular act amounts to an offense is a question of law. Because you will turn the page. Whether act of causing death, this amounts to culpable homicide or not. You will turn the pages of IPC, now erstwhile IPC, 299, 300, 304. Then you will answer that question. Therefore, he said, any question which is in English law, in English legal tradition, all questions of law are addressed to the judge, whereas the questions of facts are addressed to the jury. Of course, in India, jury system is abolished after A.M. Nanavati versus State of Maharashtra. We don't have jury system. But someone's version holds water even today. Then we will come to question of facts, because you have to plead the facts in your pleadings. It may be your blame, it may be your petition, it may be your application, it may be your supplication, it may be your complaint, maybe a fire. You have to plead the facts. Example someone gives, very beautiful example someone gives. Whether Tata, in some case saying he says some other company, whether a particular company earned a profit for the assessment year 2015-16. It's a question of fact. Because you don't turn the pages of statute book to answer this question. Therefore, someone says, any record which you will open, that becomes the question of fact. The fact assumes importance even in right of appeal also. Ordinarily, the first appeal in all civilizations, especially in colonial countries, it lies both on law and facts, subject to all just exceptions. But second appeal, ordinarily, is on substantial question of law or question of law. Therefore, you should have clarity about what is law and what is fact. Whether Alexander had come to India in BC 323 is a question of fact, because you will see the evidence, you will read the history books, you will read the contemporary writings, and will arrive at a better opinion. So it's a question of fact. Then question of opinion. Whether a person like Alexander will come to Orissa in 2030, it's an opinion. Whether a particular company is going to earn profits for the assessment year 2027-28, it's a question of opinion. Opinion can be pleaded. Archbold says opinion can be pleaded. Most of the countries' opinion is pleaded. Whether in the next election, which party will come to power is a question of opinion, because it is a rough assessment as to what is going to happen in future. It may happen, may not happen. Opinion also can be pleaded. Then question of discretion, the fourth question. These are the only four questions which will arise before the court. No other question. Even if it is 143 advisory jurisdiction also, it has to fit into one of these four categories. Now discretion. What is discretion? Cardozo in the judicial process, which my brother Nursing is very fond of, refers to discretion. Discretion is not Mughal discretion. I want to give, therefore I will give. I don't want to give, therefore I do not give. I will not give you. I have given, but I want to take back. All these are Mughal discretions, archaic view of discretion. There is one judgment by Lord Halsbury who said discretion means according to rules of reason and justice. Long ago, at least a number of decisions of our apex court that has been approved and followed by the apex court. The question is, what is discretion? According to Cardozo, discretion means not deciding a particular question this way or that way, but choosing one of the most relevant principles by the application of which you are going to resolve the question. There will be competing questions in a given context. Competing principles also will be there. You have to choose one of the best, most relevant of the principles for adjudicating a particular issue, for taking a particular decision. That becomes discretion. Ordinarily, matters of discretion are treated as questions of. There are some statutes which say even first appeal also will be on questions, substantial questions of law. For example, the Employees Compensation Act, Workmen's Compensation Act 1923, Section 30. Now it is Employees Compensation Act 1923. Statute may prescribe that appeal will be on such and such question. It may say appeal is on the question of law, or appeal can be both on the mixed question of law and facts. Several decisions we have seen which are mixed questions of law and facts. Many times we see, even in civil suits, the evidence being pleaded. Evidence should not be ordinarily pleaded unless there is very special circumstance. Evidence has to be led to prove the facts in issue and facts relevant to the facts in issue. Therefore, you are not supposed to plead the evidence, but you have to lead the evidence. But exception is where oral evidence is not taken at all. You have to plead. For example, writ petition. You have to little plead evidentiary aspect also. Petitioner came to be appointed as the district magistrate by virtue of state government's order dated so and so, so and so. Copy of the appointment order is at the exact paper. Petitioner ought to have been given the selection skill after he completed 5 years of successful service without any blemish. By virtue of rule so and so, which reads as under. So you have pleaded the rule. Law is pleaded. Because you can't plead evidence ordinarily in a writ jurisdiction, be it 226 or 227. Ordinarily, oral evidence is not let at all. So that is one exception. If you should know law, then law does not come to anybody by lottery. It does not fall down from the heavens. It does not come to you by prayers. Only Kalidasa could get knowledge from Kali. But for us, from Saraswati. But for us, it is not possible. The only way, perhaps best way, cheapest way is to turn the pages of the books. Many books are becoming destitute. In your library, in the library of Advocate General also, which I visited when I came to Cuttack. Most of the books I have seen, they remain as virgin and they die as virgin. That is an apachara to knowledge. Goddess Saraswati. Tagore said in Gitanjali, Tagore said, it was very beautifully translated to Kannada when I was in primary school. Yalli manavu nirbhayadi talayanetti niluvudu. Yalli ಜ್ಞಾನ ಸುಧಾಪಾನ ಎಲ್ಲರಿಗೂ ಸಿಗುವುದು. ಆಸ್ವತಂತ್ರ ಸ್ವರ್ಗಕ್ಕೆ ಏಳಲೇಳಲೇಳಲಿ. Tagore sang, where the knowledge is free and the mind is held high, unto this land, oh my Lord, I be stimulated to walk on. It is a land of knowledge. Bharata, India, that is Bharat, is a union of states, said Dr. Ambedkar in first article of the Constitution. India, that is Bharat. This is Bharat because Bha in English, in Sanskrit, means knowledge, light. This is a land not of warriors. If you read history of this country, if you read Will Durant, Story of Civilization, at least one volume out of 11 is dedicated for the history of Asia. That is our Oriental heritage. One, whole one. He says India is not a land of warriors. It is a land of knowledgeable people. Ha means knowledge in Sanskrit. Rat, Nirat, again Sanskrit word. Those who are engaging themselves in the acquisition of knowledge. 23 universities in the ancient India, including Nalanda, Dakshina. Your Utkala also. Utkala, Krishna Kala, combination. Therefore, we have to lead. In Bhagavad Gita, there is a shloka. Nahi jnanena satrisham pavitramiha vidyate. There is nothing as sacred as knowledge. And Prophet Muhammad used to say, ink of a scholar is holier than blood of a martyr. Bible says knowledge is power. You will find some similar sentences or well-meaning sentences better than this also in Chanda Avesta of Parsis, Torah of Jews, in the scriptures of Jehovah Witness. Therefore, knowledge is very important. And acquisition of knowledge is imperative for those who are in Saraswata Loka, that is the bar, this bar. But it's also Saraswata Loka in its own kind. I am not on. But this bar, at least few hours, one should read. I should say two instances. When Adi Shankara was asked, why you prefer Jnana Marga over Karma Marga, Bhakti Marga? Adi Shankara said, Jnana is very important for beautification of the life. He gave two examples. There was a beggar. The bowl had dilapidated. Some Pandit had told the beggar, if you pray God, he will come and give you anything you want. And he meditated, bought a beer, and the beggar asked, for what? Oh God, my bowl is dilapidated. Give me new bowl. He had sought for new bowl because he had no knowledge at all as to what should be asked. Then another example which Khalil Gibran will give you. A very hungry dog chewing a dry bone, and blood is coming from the mouth. The dog is under the impression that the bone is yielding the blood when its jaw was broken. Therefore, those who are in the profession of law, for them, reading is a must. Last one instance I should tell you before I complete this. You are all tired, I know. And this is evening also. And my Lord Honorable Chief Justice has to perhaps travel. I do not know. In England, in Ireland, if you go to English land, European land, you will not find the open courts, which you read in open courts, Jackson's Machinery of Justice, etc. Purely theoretical they are, because the doors of the courts are not kept open at all. They are completely closed, always, because extreme voltages. A very old lawyer was to argue a matter in the afternoon, but because of the extreme cold, he fainted. Doctors came, tried, did not help. Then junior, who had been to nearby bar to have some snacks, some drinks. Very fortunately, drinks are allowed in English courts even in the afternoon. But you need not worry about it. Even in America, where there is a rains in 7 states during the daytime, the American Supreme Court will not hold the proceedings. It rages. And wine is supplied by the court master to all the judges. So don't worry, you don't have that provision in the constitution in India. Then when he was about to start argument, he fainted and the doctors could not revive him. The junior came running. What has happened to my senior? He said the doctors failed to revive. Then he went, do you have a library? Old library? Yes, we have. He went to old library, brought old book of Cicero, Cicero's 12 tables, and opened that book and held to his mouth, to his nose. After having the smell of this old book, the senior got up and said, which matter I have to argue. With this, thank you so much for
Please go, sir.
I called upon our Vice President, sir, to give the vote of thanks.
Respected Honorable Justice Shri Sangam Kumar Sahoo, sir, and Honorable Justice Dixit, sir, and the Honorable Chief Justice, Honorable Chief Justice Anand, sir, and Honorable Justice Shri Pathak, sir, and Honorable Justice Mr. Sir, the Honorable Justice Senior Singh, sir, and Honorable Justice Mr. Sir. The esteemed member of the bar also present here. I, on behalf of our bar association and the entire legal fraternity, extended the vote of thanks to all the dignitaries, guests of the dais, and all of the dais for their kind participation and gracious presence to make the event fully successful. Finally, I thank all you. With these words, I conclude my vote of thanks. Once again, I thank you all. Jai Jagannath. Namaste.
ସମସ୍ତଙ୍କ ପାଇଁ ରିଫ୍ରେଶମେଣ୍ଟ ତଳେ ପ୍ଲିଜ ଫୁଡ ପ୍ୟାକେଟ୍ସ ଅଛି।